Alex here with part 137 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed, cannot be reopened, and that's because my ex-parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Just reminding my viewers as to why I give the disclaimer. If I don't give that disclaimer, 4 out of the 5 emails that I receive are from people who are emailing me about those two issues. Number one, what are you doing? Your case is going to get exploded. And then number two is, why are you doing this to your ex? And I try to explain it's educational. It's not for attacking my ex. And of course, my case cannot be ruined because my case is over, irrevocably over. Going into this video, this is another example of the judge creating more work and more frustration for himself with his previous orders and his refusal to intervene. He has stated that my ex was in compliance with the order to turn over her address because she complied with this order back how many years ago? I don't remember. 2, 3, 4 years ago? Who knows? So here I am filing yet another motion to order my ex to turn over her address yet again. And he's going to have to deal with this motion because for whatever reason, he hasn't wanted to deal with the issue up until now. In fact, I don't even know if he's the one that deals with the issue. I'm pretty sure it's the new judge who takes over. So I'm filing another motion to order my ex to turn over her address. And guys, this is why judges should really think about these orders. Instead of telling somebody to turn something over then and there, they should say, not only do you need to turn this over, but anytime this updates, you need to let your opponent or your opponent. Well, that's basically what these cases turn into. They become adversaries. You need to let the other parent know that if okay, so yes, turn over your address now, but if you move, let them know within, I don't even say a day. Let them know before you move. Let them 5 days prior to moving know that you're going to move and what your new address is going to be. If they don't put that into the order, technically your ex doesn't have to do it. And so you end up in these weird situations like this where your ex is like, I'm not going to give you my address. I already did. And you're like, hold on a second. You mean that time back in 2009? You realize it's 2013 now, right? I might need your new address and probably all the other ones that you lived at prior. In any event, none of these antics are new to any of us who are facing high conflict child custody exes. I doubt this is a surprise to any of us. It's probably a surprise to the attorneys and maybe even to the judges who just have no clue as to how high conflict child custody works. But in any event, let's go ahead and move forward now into my motion to compel my ex to turn over her address again. Here we have the motion to compel the disclosure of physical addresses, or in the alternative, for an order to show cause. Why did I ask for both? Just in case my ex's attorney stated, which I highly doubt she would have stated, that now that the court has entered its writ of mandamus, now she has to comply, and therefore my motion is superfluous because she's just going to comply now. I was pretty much wanting to make extra sure that she couldn't use the argument that there was an existing order that was enforceable by hitting her with an order to show cause in the alternative. That basically cuts that route off from her and it forces her to deal with the motion to compel. I talk about this in the video, anticipating the response. The better you get at anticipating your ex and their attorney's response, the better you get at formulating an attack plan that will cut off their paths of retreat or their redirection or deflection tactics. So, standard introductory paragraph, I identify myself as a petitioner. I indicate to the court that I'm appearing in proper person. I'm filing a motion to compel the disclosure of physical addresses. Going into the memorandum of points and authorities. Number 1, factual background. On August 25th, I and my ex were awarded, no, wait a minute. I sued my ex for custody and visitation. The next assertion is that the court awarded us joint physical and joint legal custody. The next assertion is that my ex, and that he ordered her to turn, that's this piece right here, sorry, at line 3. And the next assertion is that he is ordering her to turn over the address, the address as to where she lives to me, because that's what parents are entitled to know when they share custody of children. Next assertion is that she sought and obtained a fictitious address by through the confidential address program, and I responded by filing a petition for writ of mandamus in the Supreme Court of Nevada. Basically, as soon as she did that, I sued the government. Then the Supreme Court of Nevada responded by publishing Falcone v. Secretary of State, and I, in accordance with that publication, filed another petition in the lower court. My ex failed to appear at the hearing, and on that basis, the court issued the writ. I requested an updated physical address from my ex. She failed to respond. The court entered the formal writ of mandamus requiring my ex's disclosure of the fictitious address to me. I promptly received from the Secretary of State my ex's physical address. However, it has come to my attention that she has moved or is going to move, and she still refuses to disclose her new address. Legal analysis pursuant to Falcone v. Secretary of State. It's pretty ironic when you are citing yourself in your own court, proceeding. Here I am in my own court case against my ex, and I am citing a case named after me. It's gone on for that long, and it's become that ridiculous that there is now case law being formulated named after me because this court can't get it right. Anyway, let's go ahead and move forward. Under my own case, Falcone v. Secretary of State, I am entitled to know where my son lives. Going into the next section, the court I think I'm talking about asking here for a continuing order to disclose so that my ex doesn't just comply with the court's order every time a motion is filed. It's ironic that she is annoyed that I'm filing so many motions, but the reason I'm filing so many motions is because that's the only thing that gets her to do the thing that she's supposed to do. So in any event, here I am, I'm asking the court to give me a continuing order of disclosure so I don't have to keep coming back to court. Going into the next assertion here. If the court feels that an order would be superfluous on the basis that the existing August 26, 2009 order is sufficient, then I am asking for contempt of court. So I'm hitting on both prongs. Number one, give me an order that's enforceable. Number two, if you're not going to do that because there's an existing order that's enforceable, then lock her up. Contempt of court. Pick a path. I'm giving the court two paths. I'm giving my ex two paths. Both of them aren't good for her. She's going to have to pick one or the other. I talk about this in the video, I think it's called The Abuser's Double Bind. So I'm using the same thing against her. Going into the next section here, my ex has already been held in contempt of court within the last year. The court went so far as to specifically suspend her sentence on the condition that if she complies with court orders in the future. So if she is deemed to have failed to comply with this order, she should be not only incarcerated under the new contempt, she should also be forced to serve that suspended sentence as well. Next, we have the imposition of a civil contempt. If the court is going to use a civil contempt process, then her eventual disclosure would end her imprisonment. So the court can take here's another double bind for her. Hit her under criminal contempt or hit her under civil contempt, which is to lock her up until she complies with the court's order. Going into the next assertion here, we got mediation. Again, guys, this is my standard boilerplate get out of mediation free card. I strongly recommend you use this if you're in a high conflict child custody case. You can read it for yourself. I've used it many times and it's working. I've not been sent back to mediation and I love that. Mediation with my ex is a complete and total waste of time. Going into the conclusion, here we have the conclusion, which is that we are to disclose our physical addresses to each other immediately and that we... what is this portion here? I'm asking the court to okay, yeah, so this is, okay, I get it now. So I'm asking the court to disclose the addresses right now, to order the disclosure right now, and also to order continuing disclosure. Verification and declaration in support. This is sworn under penalty of perjury that all of the facts alleged in this document are true and correct. Certificate of Rule 5 service indicating that I've mailed this document to my ex's attorney. Motion opposition notice, which according to the check marks indicates that I do not have to pay a filing fee. List of exhibits, we have an email. I don't know why this is blank. I should have filled this in. It doesn't matter though. Let's take a look at the email. Exhibit 1. Okay, the judge issued a writ of mandamus today. The secretary and I came to an agreement on the language of the writ. What I would like to avoid. Oh, that's cool. So then, wait a minute, really? I don't remember it going through the proposed order process, but maybe it did. I don't know. What I'd like to do is avoid a new motion for contempt to see if... Okay, so I sent this to her attorney, not to my ex. What I'd like to see is if her client would agree to stipulating that we should continue to disclose the physical address at all times. By the way, guys, I think it's weird that my ex's attorney didn't respond to this. So I can understand my ex not responding, but my ex's attorney not responding, that's weird. Okay, well... She didn't respond, and then this motion gets filed. So more work for her. Going into the aftermath, I filed one document. It was a free filing, so I incurred $0 in costs. My ex did not file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have at least had to read this, and I can't remember if she even files an opposition or not. I don't think she does, but we'll find out. In any event, if she does file something, most of the time is going to go into the document that she files, not so much this document which she's reviewing. So I think it's reasonable under the circumstances to say that 15 minutes to review this motion is going to satisfy how much time the attorney probably put into reviewing it. At the rate of $250 an hour, that's going to come to $62.50 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.